In 2022, the Supreme Court of the United States struck down a century-old New York gun licensing law and, in doing so, quietly rewrote the rules for how every court in America must evaluate the Second Amendment. Overnight, the familiar balancing tests that federal judges had used for years, tests that weighed public safety against gun rights, were swept aside. In their place, the court announced a new standard rooted not in modern policy debates, but in history, specifically in whether a firearm regulation is consistent with the nation's historical tradition of gun regulation. That shift did not just affect New York, it reshaped litigation in every federal circuit. It triggered waves of new lawsuits. It reopened challenges to long-standing gun laws, and it left lower courts wrestling with a question that is as old as the Republic itself. How much does the past control the present? Here's the question I want you to consider as we begin. Should constitutional rights be defined primarily by how similar regulations existed in 1791 and 1868? Or should modern lawmakers have more flexibility to respond to today's problems? Let me know your answer in the comments, because that tension lies at the heart of the Supreme Court's latest Second Amendment standard. To understand what changed, we need to rewind. The Second Amendment itself is short, just 27 words. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For most of American history, the Supreme Court said very little about what that language actually meant. In 1939, in United States v. Miller, the court upheld a federal restriction on sawed-off shotguns, suggesting that the Second Amendment was tied to militia service. For decades after that, lower courts largely treated the amendment as connected to collective defense rather than individual self-defense. That changed dramatically in 2008 with District of Columbia v. Heller. In Heller, the court held for the first time that the Second Amendment protects an individual right to possess a firearm for self-defense within the home. The case struck down Washington, D.C.'s handgun ban and its requirement that firearms in the home be kept inoperable. 2 years later, in McDonald v. City of Chicago, the court held that this individual right applies to the states through the 14th Amendment. But even after Heller and McDonald, uncertainty remained. The court had recognized an individual right, yes, but what standards should courts use to evaluate gun regulations? Could states impose licensing requirements, magazine limits, assault weapon bans, restrictions on carrying firearms in public? In the absence of clear guidance, federal appellate courts developed a two-step framework. First, courts asked whether the regulated conduct fell within the scope of the Second Amendment. If it did, they then applied some form of means-end scrutiny, often intermediate scrutiny, balancing the government's interest in public safety against the burden on the individual's right. Under that approach, many gun regulations survived. Courts frequently concluded that even if a law burdened Second Amendment rights, it could be justified by sufficiently important public safety concerns. Then came New York State Rifle and Pistol Association versus Bruen in 2022. At issue in Bruen was New York's may issue concealed carry licensing regime. To obtain a license to carry a handgun in public for self-defense, applicants had to demonstrate proper cause, meaning a special need beyond that of the general public. In practice, that often meant showing specific threats or unique danger. The Supreme Court, in a 6-3 decision, struck the law down. But the most significant part of Bruen was not just the outcome, it was the methodology. The court rejected the two-step balancing framework used by the lower courts. It stated that the Second Amendment is not subject to means-end scrutiny like intermediate scrutiny. Instead, the court announced a new test. When the Second Amendment's plain text covers an individual's conduct, the government must justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. In other words, once a court determines that the Second Amendment's text applies, for example, that carrying a handgun is bearing arms, the burden shifts to the government. The government must show that analogous regulations existed historically, particularly around the time of the founding. This was a dramatic shift. No longer could courts simply weigh public safety against individual rights. The question became historical. Is there a well-established tradition of similar restrictions? Now, the court did not say that modern laws must be identical to founding-era regulations. Instead, it spoke of analogical reasoning. Courts must determine whether a modern law is relevantly similar to historical regulations in terms of how and why it burdens the right. This is where things became complicated. Supporters of the Bruen decision argue that it faithfully applies originalism, the idea that constitutional rights are fixed at the time of adoption. They contend that allowing judges to balance policy interests risks diluting constitutional guarantees. From this perspective, the Second Amendment deserves the same historical respect as the First or Fourth. Critics argue that the test is impractical and historically indeterminate. They point out that modern firearms, urban density, and contemporary crime problems differ dramatically from those in 1791. They question whether centuries-old analogs can meaningfully guide regulation of semi-automatic weapons, high-capacity magazines, or digital background checks. This debate moved quickly from theory to reality. After Bruen, lower courts were inundated with challenges to existing laws. One of the first major tests of the new standard came in United States versus Rahimi in 2024. Rahimi involved a federal statute that prohibits individuals subject to domestic violence restraining orders from possessing firearms. The Fifth Circuit initially struck down the law under Bruen's historical tradition test, concluding that there was insufficient founding-era precedent for disarming individuals based solely on civil restraining orders. The Supreme Court reversed. In Rahimi, the court clarified that while Bruen requires historical grounding, it does not demand a historical twin. The court emphasized that historical analogs need not be identical. They must be relevantly similar. It pointed to historical laws that disarmed individuals deemed dangerous, or who threatened harm to others. Rahimi signals something important. The court was not abandoning all modern regulation. Instead, it was refining how history should be interpreted. The key concept emerging from Rahimi was dangerousness. Historically, legislatures had authority to disarm individuals who posed a threat to public safety. This brings us to the practical implications. Imagine a state passes a law prohibiting firearm possession by individuals convicted of certain violent felonies. Under Bruen and Rahimi, courts would ask, is this conduct covered by the Second Amendment's plain text? If so, does a historical tradition support disarming individuals who are considered dangerous or who have demonstrated violent behavior? Historical evidence suggests that founding-era legislatures did impose restrictions on groups deemed dangerous or disloyal. That historical record strengthens the constitutional footing of modern felon-in-possession laws. But what about broader regulations, such as bans on certain types of semi-automatic rifles, or magazine capacity limits, or age restrictions for purchasing firearms? Here, lower courts have split. Some courts have upheld restrictions by pointing to historical regulations on dangerous and unusual weapons. Others have struck down laws, concluding that modern semi-automatic firearms are in common use and therefore protected under Heller's language. This tension reflects another foundational principle from Heller. The Second Amendment protects weapons in common use for lawful purposes, particularly self-defense. So now we have multiple interacting doctrines: plain text coverage, common use, dangerousness, and historical tradition. At this point, it's worth pausing for a moment. Do you think history provides a clear enough roadmap for judges to apply consistently, or does it invite selective interpretation? I'm genuinely interested in how you see that playing out. Share your thoughts below. Let's talk about what the new standard does not do. Bruen does not eliminate all firearm regulation. The court explicitly stated that certain shall-issue licensing regimes, those with objective criteria, are generally permissible. It also reaffirmed Heller's recognition that long-standing prohibitions on possession by felons or the mentally ill, and restrictions in sensitive places such as schools and government buildings are presumptively lawful. But even the concept of sensitive places is being litigated. After Bruen, some states expanded sensitive place designations to include subways, parks, entertainment venues, and even large portions of urban areas. Courts are now evaluating whether such expansions are historically analogous to founding-era restrictions in courthouses or legislative assemblies. The broader lesson is this: the Supreme Court has shifted the battleground from policy arguments to historical analysis. For ordinary citizens, this matters in very practical ways. If you live in a state that previously required you to show a special need to carry a handgun, that requirement may no longer stand. If you are challenging a firearm restriction, your case will likely hinge on historical research rather than statistical studies about crime rates. And if you are a legislator drafting gun laws, you now must ask a new question. Can this regulation be defended through historical analogy? There are also implications beyond firearms. Bruen represents one of the court's clearest endorsements of a history and tradition methodology. That methodology has appeared in other constitutional contexts, including certain First Amendment and due process cases. Observers are watching closely to see whether this approach expands further. Now, let's address a common misconception. Some believe that Bruen created an absolute right to carry any weapon anywhere. That is not accurate. The court reaffirmed that the right is not unlimited. It did not invalidate all permitting systems. It did not hold that any regulation lacking a precise founding-era duplicate is automatically unconstitutional. Instead, it requires a structured historical inquiry. Another misconception is that historical analysis is purely mechanical. In reality, it requires judgment. Historians disagree about the meaning and prevalence of certain colonial laws. Some regulations were regional, others were short-lived. Determining what constitutes a tradition rather than an isolated example is inherently interpretive. This interpretive space is where much of the litigation now unfolds. Consider age-based restrictions. Some federal courts have examined whether founding-era laws limited firearm access for individuals under 21. Historical militia laws sometimes required young men to possess firearms, while other statutes restricted minors' access. Courts must weigh those records and decide whether modern age limits align with historical practice, or take bans on firearms for individuals convicted of non-violent felonies. Historically, many disarmament laws focused on perceived dangerousness or disloyalty, not necessarily on any felony conviction as defined today. This has led some courts to question whether blanket felon in possession statutes are fully supported by historical tradition, at least as applied to non-violent offenders. These are not abstract debates. They affect real people. Imagine a person convicted decades ago of a non-violent fraud offense who now challenges a federal prohibition on firearm possession. Under the Bruen framework, courts must analyze whether there is historical support for permanently disarming someone in that category. Different courts have reached different conclusions. This is why the Supreme Court's guidance in Rahimi was so closely watched. By emphasizing historical practices of disarming dangerous individuals, the court signaled that the core principle is not punishment for its own sake, but prevention of harm. There is also a federalism dimension. States retain significant authority to regulate firearms, but that authority now operates within a more rigid constitutional framework. Some states have responded by carefully tailoring laws to track historical analogs. Others have tested the boundaries, prompting swift legal challenges. Throughout all of this, one thing remains constant. The Supreme Court is the final arbiter of constitutional meaning, but it often allows legal questions to percolate in the lower courts before stepping in again. We are likely still in that percolation phase. Let me offer another engagement moment here. If you were a state legislator tasked with drafting gun legislation today, would you prioritize strict historical fidelity, or would you focus on contemporary safety data and accept the risk of constitutional challenge? I'd like to hear how you would approach that responsibility. As we move toward closing, let's distill what this new Second Amendment standard truly represents. First, it marks a decisive rejection of interest balancing in this context. Courts are no longer supposed to weigh whether a law's benefits outweigh its burdens. The inquiry is anchored in constitutional text and historical tradition. Second, it elevates history to a central role in constitutional adjudication. Lawyers now marshal historians, archival documents, and founding-era statutes as primary evidence. Third, it leaves significant room for continued litigation. Terms like relevantly similar, dangerous, and common use require interpretation. That interpretation will continue to evolve. For ordinary Americans, the most important takeaway is this: constitutional law is not static. It develops through cases, controversies, and judicial reasoning. Decisions like Heller, McDonald, Bruen, and Rahimi are chapters in an ongoing story about how we balance individual liberty and public safety. If you are personally affected by firearm regulations, remember that this video is informational, Laws vary by jurisdiction, and constitutional doctrine can shift. For advice about your specific situation, consult a qualified attorney licensed in your state. We began with a question about whether constitutional rights should be defined primarily by historical tradition or by modern legislative judgment. That debate is not going away. It reflects deeper philosophies about the role of courts, democracy, and the Constitution itself. Here are the three most important takeaways. First, the Supreme Court's latest Second Amendment standard requires courts to evaluate gun regulations through the lens of historical tradition rather than policy balancing. Second, that standard does not eliminate all firearm regulation. It demands historical justification, and the court has recognized principles such as disarming dangerous individuals and regulating sensitive places. Third, the doctrine is still developing. Lower courts are interpreting and applying Bruen and Rahimi in real time, meaning the legal landscape may continue to shift. Understanding this matters because constitutional rights shape everyday life. They determine what governments can and cannot do. They influence legislation, law enforcement, and individual decision-making. And they remind us that the Constitution is both a historical document and a living framework applied to modern realities. If this analysis helped clarify a complex and evolving area of law, consider sharing your perspective below. The strength of constitutional democracy lies not only in court decisions, but in informed citizens who understand what those decisions mean. And as the Supreme Court continues to define the boundaries of the Second Amendment, one thing is certain: history is no longer just background. It is now the test.